Hi everyone, I'm Lee Pacchia and you are watching The Business of Law. Today our guest is Jim Ryan. He's a partner at Cullen Dykman. Jim is the head of the Commercial Litigation Department and also chairs the Employment Litigation Group. Welcome, how are you?
Thanks, Lee, appreciate it.
So how's business?
Business is going very well. It's 2014 was good, and we think 2015 will be even better.
How big a firm is Cullen Dykman?
We're about 170 lawyers in 6 offices, regional firm, mostly New York, but we do practice in the Northeast.
Yeah, I'm keen to get more regional players on the show because I'm interested to see how firms of this size and nature have weathered the great legal recession. Generally speaking, how have the last 5, 6, 7 years gone?
They've been actually very, very good, surprisingly good in view of the disaster of 2008. But we tend to be countercyclical. We have a large banking and finance area. We have a large corporate energy area, as well as a significant litigation practice. And the 3 work in tandem to really be able to handle the downturns. Because, for example, if lending goes down, well, the workouts, bankruptcies, and creditors' rights issues go up.
And we were talking before, you guys had a little bit of a deal. You just had an acquisition.
We had an acquisition with a small firm, that 2-man firm that came to us, and that's the type of thing we're looking for. And with those 2 gentlemen who are experts in their area, and they were able to bring in somewhere around 40 different banks, some of whom are existing clients, some of whom are new relationships. But those are the type of things we're looking for.
So I wanted to talk to you about your work in building a Title IX compliance practice, defending universities and colleges around the country. Let's go back to the beginning here. Why, from a business standpoint, would you want to develop this practice?
Well, it's part of our overall civil rights defense area. We represent municipalities, corporations, as well as colleges and universities. And we've been representing colleges and universities for about 25 years. And it used to be mostly in the Title VII arena, when a professor would not be promoted or given tenure. Usually May is the best time of year for if you represent colleges and universities, because those are when the tenure decisions were made. But over the last 2 years, 3 years, sexual assaults on campus have been grabbing media attention and, frankly, grabbing the attention of the administrations at various institutions.
Right. This is a fascinating conversation to dive into because we've seen in the last 25 years a tremendous amount of change on 2 fronts that are pertinent to this discussion. Higher education in the United States has gone through profound change in the last 25 years. I mean, profound change in the last 5 years. And we have seen this dramatic increase, at least in reporting, if not in incidents from the beginning, in sexual assault on campus. How has those 2 dynamics gone into changing the way your firm approaches this type of work?
Well, you're seeing different dynamics at work, and some are fighting against each other. As college tuitions contract due to lower admissions and lower enrollments, you're seeing less money to be put towards programs that look to assist or prevent sexual assaults on campus, and there are less dollars to throw at these programs. So we're seeing that, well, training and compliance and enforcement, the need is growing. The ability to pay for it is contracting rather rapidly due to less federal money, less tuition money, and overall less manpower.
Are colleges and universities starting to change the way they approach these issues? I mean, previously, if there was a sexual assault reported on campus in general terms, they would try their best to handle it internally. There was, some would say, a reluctance to bring in outside authorities and police departments, in, at least early on in the investigation process. Is that a tack that is being rethought?
Oh, Lee,
by administrations?
I think it's not only being rethought, it underwent a period where there was a, for lack of a better term, an overreaction, where UVA is a perfect example. Let's stop the fraternities, let's, an over-the-top reaction that unfortunately had to be retracted just this week. And so now they're looking, colleges and universities are, what's the fair approach to this? How do we make sure that we handle the alleged victims' concerns and claims properly, quickly, and efficiently, while maintaining the rights of the accused? Because don't forget, a lot of, probably close to 50% of the cases that come out of these investigations are because the investigations were improperly performed, and the accused will sue for defamation or violation of his Title IX rights.
Where do you see this practice in 5 years?
I see it leveling off. I see it over the next couple of years. There's going to be a need for proper training. There's going to be a need for scrutinization over these type of cases. But I think as the training catches up to the need, I see these things leveling off.
Jim, wild stuff. Thank you so much for stopping by.
Pleasure, Lee. Good talking to you.
Thank you. That's Jim Ryan from Cullen Dykman. If you'd like to see more of the stuff we're working on, be sure to go check us out online. You can find us at mimesiswebtv.com. You can also find us on YouTube and Twitter under the same handle. I'm Lee Pacchia. Thanks for watching.